Welcome to A Republican Professor. I'm your host, Dr. Lucas J. Mather. I'm your host. That's right. It's Wednesday, 3 December 2025, years after Jesus. We are in Loper Bright. We're going to finish this sucker, man, but not today. We got two more episodes. The last one we did was 2 September 2025, up through Roman Numeral II, letter C, in the opinion of the court, written by Johann Sebastian Roberts. Congress in 1946 enacted the APA as a check upon administrators whose zeal might otherwise have carried them to excesses not contemplated in legislation creating their offices. So starts letter C. 603 U.S. reports. The slip opinion 2024. Loper Bright overturning Chevron. I want to alert you that Richard A. Epstein said on Law Talk, I believe he said this last year, that he thought that this was a stillborn case, a stillborn baby, dead on arrival. I don't know. I don't know the future, but that's what he said. And he's been wrong about some things. So, but he's also very wise and highly knowledgeable. I'm not sure what to think of that. We're going to find out, aren't we? It was the culmination of a comprehensive rethinking of the place of administrative agencies in a regime of separate and divided powers. In addition to prescribing procedures for agency action, the APA delineates the basic contours of judicial review of such action. As relevant here, Section 706 directs that, quote, to the extent necessary to decision and when presented, the reviewing court shall decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action. That's 5 U.S. Code, Section 706, the APA, Administrative Procedure Act, which is why this is in the admin law playlist on YouTube. Okay? It further requires courts to hold unlawful and set aside agency action, findings, and conclusions found to be not in accordance with law. You're probably still thinking about that Richard Epstein quote that I mentioned, what to make of it. A lot of high hopes that Chevron would be overturned. It was by Republicans last year. All the Republicans signed on to it, 6-3. But the controversy is now whether it has any teeth unless you go after the issue of delegation and you revive a non-delegation doctrine, or depending on how you think of it in terms of originalist understanding, whether you create one. So I think I'm not going to predict the future here. The APA thus codifies for agency cases the unremarkable yet elementary proposition reflected by judicial practice dating back to Marbury that courts decide legal questions by applying their own judgment. Makes sense to me. We're on page 14. It specifies that courts, not agencies, will decide all relevant questions of law arising on review of agency action. Section 706. emphasis added, even those involving ambiguous laws, and set aside any such action inconsistent with the law as they interpret it. And it prescribes no deferential standard for courts to employ in answering those legal questions. That omission is telling because Section 706 does mandate that judicial review of agency policymaking and fact-finding be deferential. See Section 706(2)(a). Agency action to be set aside if arbitrary, capricious, or abuse of discretion. Section 706(2)(e). Agency fact-finding and formal proceedings to be set aside if unsupported by substantial evidence. In a statute designed to serve as the fundamental charter of the administrative state, Congress surely would have articulated a similarly deferential standard applicable to questions of law had it intended to depart from the settled pre-APA understanding that deciding such cases was, quote, exclusively a judicial function, unquote. But nothing in the APA hints at such a dramatic departure. Now recall, this is me, recall the APA was enacted into law in 1946. So they're talking about a statute that is 80 years old. Remember. Okay. On the contrary, by directing courts to interpret constitutional and statutory provisions without differentiating between the two, Section 706 makes clear that agency interpretations of statutes, like agency interpretations of the Constitution, are not entitled to deference. Page 15 at the top. How are you guys doing? You getting this? This is, I think I don't know what number of episodes we are. We're over a half dozen on Chevron Deference Deep Dive. Wouldn't you say? Aren't we at we're at over a half dozen, right? Okay, you'd have to count. Yeah. So I'm very proud of you. I should have started with that. I'm very proud of you for hanging in there because this is not for the faint of heart. I told you this is one of the hardest things to talk about on the podcast. I told you that because it takes so long to get your mind wrapped around the sucker. You have to sit still. You have to quit fidgeting for a long time, or at least take it in chunks. The text of the APA. Oh crap. I skipped a sentence. Under the APA, well, let me read that last sentence real quick again. Bottom page 14, top of page 15. On the contrary, talking about the APA, 1946, Administrative Procedure Act. On the contrary, by directing courts to interpret constitutional and statutory provisions without differentiating between the two, Section 706 makes clear that agency interpretations of statutes, like agency interpretations of the Constitution, are not entitled to deference. Under the APA, it thus remains the responsibility of the court to decide whether the law means what the agency says. The text of the APA means what it says, and a look at its history, if anything, only underscores that plain meaning. According to both the House and the Senate reports on the legislation, Section 706 provided that questions of law are for courts rather than agencies to decide in the last analysis. That's from 1980, House of Representatives report. There's also one from 1946. Some of the legislation's most prominent supporters articulated the same view. Okay, and then there's backup and evidence of that. Even the Department of Justice, an agency with every incentive to endorse a view of the APA favorable to the executive branch, opined after its enactment that Section 706 merely restated the present law as to the scope of judicial review. I think this is a pretty good argument. I'm looking at the footnotes right now to determine there was a chunky footnote back on page 13. And I'm not going to do that one. That's worth looking at. These footnotes are definitely worth looking at. Let me look at the one on bottom of page 15. Okay. This one might be worth saying. Well, they're both worth saying, but I'm going to get to footnote 4. The dissent observes that Section 706 does not say expressly that courts are to decide legal questions using a de novo standard of review. That much is true, but statutes can be sensibly understood only by reviewing text in context. Since the start of a republic, courts have decided questions of law and interpreted constitutional and statutory provisions by applying their own legal judgment. Setting aside its misplaced reliance on Gray and Hurst, the dissent does not and could not deny that tradition, but it nonetheless insists that to codify that tradition, Congress needed to expressly reject, I think you should say expressly to reject, a sort of deference the courts had never before applied and would not apply for several decades to come. It did not. The notion that some things go without saying applies to legislation just as it does to everyday life. All right, that was a decent footnote, and I'm glad I paid attention to it. Page 16. The present law, as we have described, adhered to the traditional conception of the judicial function. Various respected commentators contemporaneously maintained that the APA required reviewing courts to exercise independent judgment on questions of law. Professor John Dickinson, for example, read the APA to impose a clear mandate that all questions of law shall be decided by the reviewing court itself and in the exercise of its own independent judgment. Professor Bernard Schwartz noted that Section 706 would seem to be merely a legislative restatement of the familiar review principle that questions of law are for the reviewing court, at the same time leaving to the courts the task of determining in each case what are questions of law. And Professor Louis Jaffe, who had served in several agencies at the advent of the New Deal, thought that Section 706 leaves it up to the reviewing court to decide as a question of law whether there is discretion in the premises, that is, whether the statute at issue delegates particular discretionary authority to an agency. The APA, in short, incorporates the traditional understanding of the judicial function, under which courts must exercise independent judgment in determining the meaning of statutory provisions. You see the separation of powers here. You see the concern that Republicans on the Supreme Court have for the separation of powers. I don't like to predict the future. I could venture a prediction of the past. I think it's a lot more important to concern yourself with a proper understanding of the past before you go out there with your dip in your mouth trying to predict the future. Okay? Somebody's asking about my vest that I have on. It's a Defense Language Institute vest. Yes, I'm an alum. Presidio of Monterey. What's my hat say? Greta's Guns, Sincimi Valley. Yeah. Yeah, I have done business with them. Yeah. Yeah. Greta is the name of the dog. It was started by a detective. He's since died. The ownership is passed on to one of his employees, I think. Yeah, he was a detective, LAPD, for decades. Greta was his dog. I think he might have been homosexual, actually. So Greta is not his girlfriend or his wife, his dog. I think she was a bulldog. Yeah, yeah, it's great. I used to go there on my breaks between Moorpark College and Cal State Northridge. Anyway, let's get back to this. What enough about what I'm wearing? It's a Pendleton. This orange shirt, yeah, it's 100% wool. It's a Pendleton. Well, thank you. Appreciate it. Okay, let's keep going. Come on. Um, The APA, in short, incorporates the traditional understanding of the judicial function under which courts must exercise independent judgment in determining the meaning of statutory provisions. In exercising such judgment, though, courts may, as they have from the start, seek aid from the interpretations of those responsible for implementing particular statutes. Such interpretations constitute a body of experience and informed judgment to which courts and litigants may properly resort for guidance consistent with the APA. And interpretations issued contemporaneously with the statute at issue and which have remained consistent over time may be especially useful in determining the statute's meaning. In a case involving an agency, of course, the statute's meaning may well be that the agency is authorized to exercise a degree of discretion. Congress has often enacted such statutes. For example, some statutes expressly delegate to an agency the authority to give meaning to a particular statutory term. Others empower an agency to prescribe rules to fill up the details of a statutory scheme or to regulate subject to the limits imposed by a term or phrase that leaves agencies with flexibility. By the way, the sentence that says others empower an agency to prescribe rules to fill up the details of a statutory scheme, that's quoting Wayman versus Southard, 10 Wheaton, oh man, uh, 1 and page 43. That's from 1825. And you know by the citation of Wheaton, because that's before the U.S. reports. Wheaton, if you don't know, that's an old Supreme Court reporter. That's when it was private. There were private people that would publish this stuff. Um, when the best reading of a statute is that it delegates, I'm just checking these footnotes really quick. Yeah, I probably should just take a look at my notes. Hold on one sec. Let me look at my notes real quick because I don't know why I don't. Let me see. The text of the APA means what it says, page 15. I say, why did it take the court so long to see this? I'd be happy to hear what you have to say. I mean, why would it take so long for the court to say that the APA means what it says? Um, I underlined on page 16, the APA, in short, incorporates the traditional understanding of the judicial function. We talked about the separation of powers. In other words, they're saying, we're not reinventing the wheel here. Don't get too excited here. Makes you wonder why the Democrats are lockstep against this. You know, you better think about that. Let me take a look. I don't have any comments on these footnotes, so I'm going to skip the footnotes, which is good. Means we can get out of here faster. The best reading of a statute is that it delegates discretionary authority to an agency. The role of the reviewing court under the APA is, as always, to independently interpret, and he loves these split infinitives, independently to interpret the statute and effectuate the will of Congress, subject to constitutional limits. Makes sense to me. We're on page 18 at the top. Loper Bright Enterprises versus Raimondo, 2024. Republicans 6-3, lockstep against Democrats. In the dissent, lockstep against the Republicans in the majority. Overturning Chevron deference. What is going on here? The courts fulfill that role by recognizing constitutional delegations. That's a key issue right there. Okay. I don't think I've looked at that law review article. The court fulfills that role. What role? Go back to page 17 at the bottom. When the best reading of a statute is that it delegates discretionary authority to an agency, the role of the reviewing court under the APA is, as always, and I'm fixing the split infinitive here, independently to interpret the statute and effectuate the will of Congress, subject to constitutional limits. The court fulfills that role by recognizing constitutional delegations, fixing the boundaries of the delegated authority, and ensuring the agency has engaged in reasoned decision making within those boundaries. By doing so, a court upholds the traditional conception of the judicial function that the APA adopts. So, what you got here is basically a defense of the Administrative Procedure Act. They say the Administrative Procedure Act is fine insofar as the administrative state goes, policing the administrative state. And what our role is to maintain our independence. Congress cannot take our independence away. We punted on first down our independence away, and that was inappropriate. We're taking it back. We're going to take it back. Okay, we're going to page 35, but we're not going to get all of that done today. So from 13 to 35 is what? What is 13? 35. I got my handy dandy calculator. I just want to make sure we go about halfway. We got 22 pages, so we got to do 11 pages plus 13. Okay, so we got to do till page 24. Okay, and we're on page 18. All right, we're on Roman numeral III. The deference that Chevron requires of courts reviewing agency action cannot be squared with the APA. In the decades between the enactment of the APA and this court's decision in Chevron, courts generally continued to review agency interpretations of the statutes they administer by independently examining each statute to determine its meaning. You see this? Independently. Separation of powers. Article 3. We're independent, we're different. We're separate, but equal. Separate, but equal, baby. As an early proponent and later critic of Chevron recounted, courts during this period thus identified delegations of discretionary authority to agencies on a statute-by-statute basis. Chevron, decided in 1984 by a bare quorum of 6 justices, triggered a marked departure from the traditional approach. So they're saying the APA wasn't the problem. Congress, insofar as it goes on this, was not the problem. The court was the problem during the Reagan administration. The Chevron court in 1984 created a problem. And what they're doing here in Loper Bright is fixing it. All Republicans. The question in the case was whether the EPA regulation allowing states to treat all of the pollutants emitting devices within the same industrial grouping as though they were encased within a single bubble was consistent with the term stationary source as used in the Clean Air Act. To answer that question of statutory interpretation, the court articulated and employed a now familiar two-step approach broadly applicable to review of agency action. We're on page 19 at the top. The first step was to discern whether Congress had directly spoken to the precise question at issue. The court explained that if the intent of Congress is clear, that is the end of the matter, and courts were therefore to reject administrative constructions which are contrary to clear congressional intent. To discern such intent, the court noted a reviewing court was to employ traditional tools of statutory construction. So he's going over the famous or infamous Chevron deference test. So this is the problem here that the court created without mentioning the APA. Then that's hard. I mean, that this will blow your mind without mentioning the APA. Wow. Wow, 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 wow. Hmm. What could possibly go wrong? Without mentioning the APA or acknowledging any doctrinal shift, I mean, what could possibly go wrong here? The court articulated a second step applicable when Congress had not directly addressed the precise question at issue. In such a case, that is, a case in which the statute was silent or ambiguous with respect to the specific issue at hand, a reviewing court could not simply impose its own construction on the statute as would be necessary in the absence of an administrative interpretation. A court instead had to set aside the traditional interpretation, the interpretive tools, and defer to the agency, that is, the executive, if it had offered a permissible construction of the statute, a permissible one. Even if not, the reading the court would have reached if the question even if not the reading the court would have reached if the question initially had arisen in a judicial proceeding. That directive was justified, according to the court, by the understanding that administering statutes required the formation of policy to fill statutory gaps, by the long judicial tradition of according considerable weight to executive branch interpretations, and by a host of other considerations, including the complexity of the regulatory scheme, EPA's detailed and reasoned consideration, the policy-laden nature of the judgment supposedly required, and the agency's indirect accountability to the people through the president. Page 20 at the top. That was all the Chevron test. Should I read that again? You're thinking, no, 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 I don't. Well, you can rewind it if you want. Remember that you got the first step on page 19, then the second step, and then you've got employing this new test. The court concluded that Congress had not addressed the question at issue with the necessary level of specificity, and that EPA's interpretation was entitled to deference. That was Reagan's EPA. By the way, it was Gorsuch's mother that was running that shop at the time. Did you know that? Well, we covered it. Gorsuch is correcting his own mother here. Both Republicans, by the way. And I remember I've billed this as Republicans are saying, yeah, we caused this problem and we're fixing it. We're identifying the problem and we're fixing it. Now the Democrats are getting in the way of fixing it. It's interesting. All right. Well, employing this new test, the court concluded that Congress had not addressed the question at issue with the necessary level of specificity, and that EPA's, that is Reagan's EPA, that is Ann Gorsuch's EPA, Neil Gorsuch's mother, he's on the Supreme Court voting against her now, that EPA's interpretation was entitled to deference. It did not matter why Congress, as the court saw it, had not squarely addressed the question, or that the agency had from time to time and changed its interpretation. The latest EPA interpretation was a permissible reading of the Clean Air Act. So under the court's new rule, that reading controlled. It's like a ping pong ball going back and forth, depending on who gets elected. The law supposedly stays the same. The interpretation is changing like a ping pong ball. You see the problem with the rule of law here? How could that possibly be if the law itself is remaining the same? Well, then Congress doesn't have to do a damn thing. I mean, it used to be back in my day, to change the effect of the rule of law, Congress had to get in there and change the damn law. Well, under Chevron, they don't. The president can change the law under these conditions. And the Republicans on the Supreme Court are saying there's something really wrong here. This is a basic problem with separation of powers. It's not a highfalutin problem. It's basic. It's fundamental. Initially, Chevron seemed destined to obscurity. The court did not at first treat it as the watershed decision it was fated to become. It was hardly cited in cases involving statutory questions of agency authority. But within a few years, both this court and the courts of appeal were routinely invoking its two-step framework as the governing standard in such cases. As the court did so, it revisited the doctrine's justifications. Eventually, the court decided that Chevron rested on a presumption that Congress, when it left ambiguity in a statute meant for implementation by an agency, understood that the ambiguity would be resolved first and foremost by the agency and desired that agency rather than the courts to possess whatever degree of discretion the ambiguity allows. Mm. Mhm. Page 21 at the top. Neither Chevron nor any subsequent decision of this court attempted to reconcile its framework with the APA. Okay, this is the heart and soul, along with the separation of powers issue, which this goes right along with it because the APA comes out of Congress, right? The court is trying to say here, the Republicans on the Supreme Court are saying, Congress, you got to get back in the game and start acting like adults. You can't punt on first down to the president to make laws, and then you just sit back and watch the ping pong ball go back. And meanwhile, business people are like, what the hell is going on here? We don't know what these laws mean. It can't be that the law is whatever the president says it is under these conditions. Congress is supposed to make the laws. And that means they have to make the laws with a certain level of specificity. Otherwise, we don't even know what the hell's going on. We can't predict the future. We can't make plans for compliance. We don't have any fair notice, which is an essential element of due process. Now we're in number 1 here. Okay, so neither Chevron nor, well, this is letter B. It's very short. Neither Chevron nor any subsequent decision of this court attempted to reconcile its framework with the APA. This is Roman Numeral III.B. It's a short paragraph. The law of deference that this court has built on the foundation laid in Chevron has instead been heedless of the original design of the APA. That's pretty telling. That's pretty damning, I would say. Yeah, this is not good. We're going to read number 1, okay? Page 21. Chevron defies the command of the APA that the reviewing court, not the agency whose action it reviews, is to decide all relevant questions of law and interpret statutory provisions. Section 706. It requires a court to ignore, not follow, the reading the court would have reached had it exercised its independent judgment as required by the APA. Note 11 at Chevron. Jeez. And although exercising independent judgment is consistent with the respect historically given to the executive branch interpretations, Chevron insists on much more. That is, the Supreme Court in 1984 insisted. Okay, the court overstepped its power. It overstepped its power, ironically, by saying, we're so powerful that we can now say that we're not powerful enough to get in the action. Well, that's the same thing as saying that you've overstepped your bounds because you're saying you can neglect your judicial duty. You do not have the power to do that under the Constitution. So Chevron insists on much more. It demands that courts mechanically afford binding deference to agency interpretations, including those that have been inconsistent over time. This is not cool. Law is not supposed to be inconsistent over time. The exact same text of what comes out of Congress is not supposed to be inconsistent over time. It's the same damn text. If Congress isn't getting in there and changing it, then it should stay the same. Congress needs to get back in the game. The courts, according to Peter Wallison in Judicial Fortitude, see that episode that I did uh, interacting with my mentor, Michael Uhlman, in his review of that book. I'll link that to this in the notes on YouBoob. Uh, Peter Wallison says the courts have to do their job, getting back in the game, doing their judicial duty, forcing Congress to clarify and update laws, not the executive. Still worse, that is Chevron, the Supreme Court in 1984, forces courts to do so even when a pre-existing judicial precedent holds that the statute means something else, unless a prior court happened to say that the statute is unambiguous. That regime is the antithesis of the time-honored approach the APA prescribes. In fretting over the prospect of allowing a judicial interpretation of a statute to override an agency's interpretation in a dispute before a court, Chevron turns the statutory scheme for judicial review of agency action upside down. Chevron cannot be reconciled with the APA, as the government and the dissent contend, by presuming that statutory ambiguities are implicit delegations to agencies. That's a very important thing that Roberts just said there, bottom of page 21. I'll read it again. Chevron cannot be reconciled with the APA, that is the Administrative Procedure Act of 1946, as the government, and that's the Biden administration at the time. Remember, this is 2024, the summer, remember? As the Biden executive branch and the dissent, all Democrats, contend. Notice it's all Democrats on one side. By presuming that statutory ambiguities are implicit delegations to agencies. Well, of course they want delegation to the agencies. They want to be able to do what they want to do in the Biden administration, right? Page 22 at the top. Presumptions have their place in statutory interpretation, but only to the extent that they approximate reality. Chevron's presumption does not, because an ambiguity is simply not a delegation of law interpreting power. Chevron confuses the two. He's quoting Cass Sunstein there in 1989, and Cass Sunstein is a Democrat. Very interesting. As Chevron itself noted, ambiguities may result from an inability on the part of Congress to squarely answer. There's a split infinitive again. What is going on here, Roberts? Kramer, what is going on here? Split infinitives, Jerry. To squarely to answer the question at hand, or from a failure to even another split infinitive, even to consider the question with the requisite precision. In neither case does an ambiguity necessarily reflect a congressional intent that an agency, as opposed to a court, resolve the resulting interpretive question. And many, or perhaps most, statutory ambiguities may be unintentional. Oh, I agree with that. Yeah, that is exactly right. How can it be a delegation of power if it's unintentional? That's such a basic point. Many, or perhaps most, statutory ambiguities may be unintentional. As the framers recognized, ambiguities will inevitably flow from the complexity of objects. Yeah. The imperfection of the human faculties, and the simple fact that no language is so copious as to supply words and phrases for every complex idea. That's Federalist number 37. Courts, after all, routinely confront statutory ambiguities in cases having nothing to do with Chevron, cases that do not involve agency interpretations or delegations of authority. Of course, when faced with a statutory ambiguity in such a case, the ambiguity is not a delegation to anybody, and a court is not somehow relieved of its obligation to independently interpret another split infinitive, independently to interpret the statute. Courts in that situation do not throw up their hands because Congress's instructions have supposedly run out, leaving a statutory gap. Courts instead understand that such statutes, no matter how impenetrable, do, in fact, must have a single best meaning. The Democrats disagree with this. But the Republicans also didn't really pull their weight until 2024 on this. Here's a very interesting question for you. Why did it take Republicans so long to come to this answer? Why is it just in 2024, now that there's six? And you could ask the same question about the Second Amendment jurisprudence. Why did it take you so long to get Bruin in 2022? You had plenty of time after McDonald versus Chicago. What the hell is going on here? Why does it take so long? It took you daggum 12 years. What in the world are you doing? Well, I think it has to do with it takes a long time for peer pressure to wear off and for you to get so sick of these problems that finally you're just like, okay, that's it. But how much suffering could have been averted? That is the whole point of having written statutes. Every statute's meaning is fixed at the time of enactment. Yeah, page 23 at the top. So instead of declaring a particular party's reading permissible in such a case, courts use every tool at their disposal to determine the best reading of the statute and resolve the ambiguity. In an agency case, as in any other, though, even if some judges might or might not consider the statute ambiguous, there is a best reading all the same. The reading the court would have reached if no agency were involved. And Congress, if you want the courts to interpret the statute differently, then get in there and fix the wording, spruce it up a bit. It therefore makes no sense, Roberts continues on page 23 in the middle, to speak of a permissible interpretation that is not the one the court, after applying all relevant interpretive tools, concludes is best. Amen. This is the heart and soul of this opinion right here, right there. He just said it. Page 23 in the middle, second paragraph down. Well, the one that starts in an agency case. I'm going to read that sentence again. Key sentence. It therefore makes no sense to speak of a permissible interpretation that is not the one the court, after applying all relevant interpretive tools, concludes is best. In the business of statutory interpretation, if it is not the best, it is not permissible. Yeah. Perhaps most fundamentally, Chevron's presumption is misguided because agencies have no special competence in resolving statutory ambiguities. Courts do. The framers, as noted, anticipated that courts would often confront statutory ambiguities and expected that courts would resolve them by exercising independent legal judgment. And even Chevron itself reaffirmed that the judiciary is the final authority on issues of statutory construction and recognized that in the absence of an administrative interpretation, it is necessary for a court to impose its own construction on the statute. How you guys doing? We're almost done. We got a couple sentences left. How are you doing? Put your comments in. Put your questions. We're almost done for today. Chevron gravely erred. Yeah, yeah. Chevron gravely erred, though, in concluding that the inquiry is fundamentally different just because an administrative interpretation is in play. The very point of the traditional tools of statutory construction, the tools courts use every day, is to resolve statutory ambiguities. That's the very point. He's talking about jurisprudence here, guys. He's talking about jurisprudence, the philosophy of textual interpretation in law. The very point of the traditional tools of statutory construction. The tools courts use every day is to resolve statutory ambiguities. That is no less true when the ambiguity is about the scope of an agency's own power, perhaps the occasion on which abdication in favor of the agency is least appropriate. Amen. I'm not sure if it goes far enough, but amen. And so far as it goes, Loper Bright Enterprises versus Raimondo. This is bottom page 23. We've gone up to number 2 in a Roman numeral 3, letter B. Okay. So we went through Roman numeral 3, letter B, number 1 just now. We are left to do number 2 at the bottom of page 23, top of page 24 next time. TYSM, thank you so much for joining me on the Republican Professor podcast. I've been your host, Dr. Lucas J. Mather. Today is Wednesday, 3 December 2025 years after Jesus. We'll talk to you later.